Hello, everybody. How are y'all doing this fine Sunday? I drove down from Atlanta today, and on the way down was listening to some court and heard some interesting stuff that I thought y'all would enjoy. Um, this is the first one I caught my attention.
Jordan, can you place Miss Bronstein in a breakout with AC/DC? Isn't that a rock band? That is rock. Yes, it is. Aging myself. Okay.
Yeah, I thought that was cute. Well, here's the cases that I caught that interest me. Something to think about as you're watching these. What's the difference between the way the DV is dealt with as far as the women and the men, and see if you see what I saw.
18, Swain.
Mr. Otis Swain is 22 CR 008580F, accused of simple battery from December 29, 2022. Mr. Swain, you've been advised of your right to remain silent, and your attorney is going to be Ms. Woodbury. Mr. Tucson, any priors?
Second arrest, last arrest was earlier this month. Battery on a female who's pregnant.
Okay. Mr. Borger, what's your bond recommendation?
Thank you, Honor. The state's asking for either a $3,000 cash bond or a $1,300 surety bond, along with the conditions of no further contact with Ayanna Swain, that's spelled Ayina Swain. Stay away from 3092 Grove Circle, that's in Hapeville. Enrollment in the anger awareness class, along with an ankle monitor. Your Honor, as you've already heard, it's been a long December for Mr. Swain. He was arrested earlier this month for battery against a pregnant woman. In this case, he was having a fight with a friend, and that's when his sister, the victim in this case, wanted to step in and just try to calm Mr. Swain down, and that's when he hit Ms. Swain in the face. So you know, it's signature bonds for cases like this that concerns the state, because he is obviously a risk of reoffending. I know that we've reached out to Ms. Swain along with her mother, Mr. Swain's mother, and they're absolutely beside themselves. He clearly has an anger problem. They're terrified. They don't want him to come back to the home. Right now, they don't want to see him. I know that they are on Zoom, so I would yield time for them to speak. But it's clear that he has a risk of reoffending, and should have either a cash bond or a very high surety bond, due to his inability to behave after just being arrested earlier this month.
Ms. Woodbury?
Yes, Your Honor. Mr. Swain is only 17 years old. I did not hear any failures to appear in that history, so we can have faith that he will show up for court. Judge, he contests these allegations. He does not agree with the state's version of events. He did go up to the 11th grade at South Atlanta High School. He's working on getting his GED, he tells me, though he's not currently employed, but I believe he may be looking for work. Judge, he can't afford a bond, so we have to ask for a signature bond.
Bond set at $2,000. It is a surety bond. This is his second domestic violence matter in 30 days. Due to this particular reoccurrence, he doesn't qualify for a signature bond. No contact with Ayanna Swain, and to stay away from the Grove, was it the Grove Road location in Hapeville?
Correct, Your Honor.
Okay. No alcohol, no drugs, no weapons, and his next court date is January 12th.
And Your Honor, there is a Swain on the Zoom. If we could allow her the opportunity to speak, because again, this is a very quickly after an arrest from another domestic violence situation.
All right. If there is, I have a Ruby
Hello?
Swain. Is that
okay? This is Amelia. This is his mother.
All right.
Can you hear me?
Yes, are you Miss Brown?
Yes.
All right, Ms. Brown, if you'd like to raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Yes, ma'am. What would you like to tell me?
I'm just concerned about my son's mental condition. He's taken medication before, and we can't deal with his anger issues here, you know. It was an altercation, like he said, with a family member, with one of his friends, and my daughter intervened, and that's how the altercation occurred, you know, and my mom
right.
is hurt behind it,
Miss
and the
Brown,
family's just
Miss
Mhm.
Brown, I'm going to stop right there. If you're saying that there is a medical condition attached to Otis's situation,
yeah. I would like to see if he
I
could get
would recommend that you contact the public defense attorney, Ms. Rose Woodbury.
Mhm.
Ms. Woodbury, if you can reach out and give Ms. Brown your phone number or an email. That way, the public defender's office can then see if he qualifies for any kind of alternative program
Okay.
that would look into this medical issue.
Yeah, because no one wants him around until he can get help.
And
Because
Ms.
he
Brown, if you continue making statements like that, you're not helping your son's case.
okay.
All right.
I'll reach out to Miss Brown.
Okay. Ms. Brown, do you know how to use chat?
Yes, ma'am.
All right. Put your phone number directly to Miss Rose Woodbury.
Okay.
All right. Thank you.
Sure.
Let's mute A. Brown, please. Thank you. Next case,
Yeah, just think you got to tell the court that about your son. That's terrifying. As a father, oh my, bad stuff there.
Court two.
Position 19, Tate.
Cameron Tate is accused of theft by deception from December 21st, 2022 in case number 22 CR 008581D. Mr. Tate, you've been advised of your right to remain silent, and your attorney is Ms. Woodbury. Mr. Broker, can you tell me again who was the employer? I can't recall whether it was Walmart or Target. Or
It was
Kroger.
neither, Your Honor. It was Kroger.
Kroger, okay. And do you have any objection to a signature bond through pretrial and to stay away from the Kroger store in question?
Yes, Your Honor, we do have an objection. I'd be asking for a $600 cash bond. That way the bond can be used as restitution to Kroger if there is even restitution needed. We would like to stay away. And again, the reason for coming in with this cash bond is that this defendant has been arrested 3 times, all for theft related matters. Burglary from 2019, entering an auto from 2019. So it just seems like he has no intention of slowing down, which is why we're coming in with the cash.
And those priors, those were under for incidences when he was under 17. Would that be correct?
Yeah, correct, Your Honor, from 2019.
All right. Ms. Woodbury?
Yes, Judge. He's 18 years old. I don't believe he has any adult history. My biggest concern is that he's currently enrolled in 11th grade at Centennial High School. He lives with his parents and siblings. I just want him to be able to get back to school. So we would be asking.
I'm sorry, which school was it?
Centennial High School.
Is that the one in Roswell?
I believe so, Judge.
And who will be co-signing his bond?
Judge, I think it will be one of his parents, but I'm not 100% sure.
We need a name.
Okay. Mr. Tate, do you know if one of your parents could co-sign your bond?
Yes, ma'am. My mom, Sharika Yarbrough.
The name again?
Sharika Yarbrough.
Spell it, because if it's a wrong spelling, she can't co-sign.
SHERICAYARBROUGH.
Sharika Yarbrough, YARBOROUGH.
Yes, ma'am.
Okay. The bond's going to be set at $5,000. It's going to be a signature bond through pretrial services. Mr. Tate will report to pretrial once a month. He will attend and complete classes with Centennial High School. I believe it's in Roswell or Atlanta. I know it's somewhere near Holcomb Bridge Road. That's all I remember. Is that the one you attend?
Yes, ma'am.
All right. You are subject to a curfew, a 24-hour, 7-day curfew. You're only allowed to step out of your home for school, to attend court, or to see your attorney, for medical reasons, and to attend church if you go to church. Your mother, Sharika Yarbrough, must co-sign your bond. You are to stay away from all Kroger stores, not just the one in question, but from all of them. So since you're subject to a curfew, there is no reason for you to go Krogering at any time. And definitely stay away from all Kroger shops.
My wife and I, we go Krogering on Friday night. That's our date night. Actually went New Year's Eve Krogering.
Your next court date will be sent to you at your Grove Circle address. Is that your current address?
No, ma'am.
What is your current address?
921 Jasmine Parkway.
Repeat.
921 Jasmine Parkway.
Jasmine Parkway.
Yes, ma'am.
What city?
Alpharetta, Georgia.
Repeat.
Alpharetta, Georgia.
Is this the same address that would appear on your mother's ID?
Yes, ma'am. It should be.
All right. Mr. Tucson, I'm not waiving the utility requirement. So if Ms. Yarbrough appears, she will need to present you with a government issue ID as well as a utility bill.
Once his public defender knows that.
Ms. Woodbury, please advise Ms. Yarbrough that that's what she'll need to present. The utility bill must reflect the address of Jasmine Parkway as well as the her ID.
Okay.
All right. Thank you.
I think Judge thinks something's up, that they're going to try to get somebody else to come in there and sign for him.
And we'll need to, and Mr. Tate, you'll need to update, or Ms. Woodbury, you need to make sure that his address is updated on Odyssey.
Yes, Judge.
Okay, moving on. We have, who?
This is position 20, Taylor.
All right. Marlon Christopher Taylor is accused of criminal trespass from December 30th, 2022. Mr. Taylor, your case number is 22 CR 008-582H. You've been advised of your right to remain silent, and your attorney is Ms. Woodbury.
39 total. Between Florida, Alabama, and Georgia. Last arrest was 2020 probation. Another 2020 probation. 2020 possession of drug-related objects. It was dismissed. 2019 probation. He got a lot of probation violations.
All right, thank you. Mr. Borger?
Thank you, Your Honor. The bond is set at a $1,000 surety bond. We'd like to keep that bond the same. Again, multi-state offender, multiple probation violations, multiple FTAs. The state's not exactly confident that Mr. Taylor will reappear at his next court date, so we'd like to keep some surety involved.
Ms. Woodbury?
Yes, Judge. I fear Mr. Taylor is not going to be able to make any kind of bond that he has to pay for. He is homeless. This allegation involves just existing in his tent, not bothering, no allegations of violence or anything like that. Judge, he is a veteran. He tells me that he did graduate from a 2-year college, Hutchinson Junior College. His last job was working as a cook at Georgia State.
All right, thank you. Bond set at $500 is a signature bond through the jail. He's to stay away from 339 Old Wheat Street in Atlanta, Georgia, the entire parking lot. He cannot return to that parking lot. And how, Ms. Woodbury, how would we notify him of its next court date?
Yes, Judge. Well, he did not have an address that he was able to give me. He did have a phone number that he gave me.
Is that the one ending in 9780?
No.
Oh, sorry. No, I don't have a phone number on file.
The phone number he gave me was 404-990-5856. Mr. Taylor, is there any other address you can think of where,
I have a mailing address,
okay, what is it?
328 Irving Street, Unit
Spell
B,
it.
IRWIN,
Urban Street.
Unit B,
Zip code.
30313, I believe it is.
All right. We will update your address and we will send you notice for your next court date. If you don't show up, we'll have to issue a warrant for your failure to appear.
Yes, ma'am.
How much was that?
It was a 500 signature bond through the jail to stay away from Old Wheat Street, the parking lot. Thank you.
Position 21, Toussaint Taylor.
Case number 22 CR 008583J, State versus Mr. Taylor, accused of simple battery, domestic violence from December 29th, 2022. Any priors, Mr. Howard?
15 total. 2015 FTA, suspended license. DUI conviction, 2015. History out of Florida, assault on a female that was dismissed from 2012. 2009, assault on a female that was dismissed. Assault with a deadly weapon conviction, 2005. And the 03, assault on a female.
Thank you. Mr. Berger?
Thank you, Your Honor. The state's asking for a $3,000 surety along with the conditions of no further contact with Miss Rhonda Wynn, WYNN. Stay away from 3290 Valley Bend Road. Enrollment in the anger awareness class, along with alcohol drug evaluation and any treatment deemed necessary, and no guns, drugs, and alcohol while on bond. Your Honor, I understand that this defendant threw a beer can at his living girlfriend's face. That's Miss Wynn. With this, we have a defendant here, multi-state offender, history of violence, violent convictions, and then also some alcohol related convictions like this DUI from 2015, FTA from 2015. So the state, again, where the state's not encouraged by this defendant's history of violence and substance abuse and would like to see some treatment so that we can mitigate some of that while he is out on bond. Nothing further.
Thank you. Ms. Woodburn?
Yes, Judge. So Mr. Taylor, he's 53. He's gainfully employed as a subcontractor at CCS Residential Community Solutions. He maintains his innocence and contests the state's version of the facts. I did not hear in the recitation of his history that he was a convicted felon. Judge, if the court is inclined to issue a stay away from that address, we would be asking for one trip with an officer. He tells me that his name is on the lease. Nothing further.
Bond set at 1,500. It is a surety bond. No contact with Rhonda Wynn. Stay away from 3290 Valley Bend Drive in Atlanta, Georgia. He may return one time only with a police officer to retrieve his personal belongings. Within 30 days of being released, he must update the court with his new address. His next court date is January 12th, 2023, and that date will change if he does make bond before January 12th. Thank you. Oh, no alcohol, no illegal drugs, and no weapons.
You're done. Position 22,
State versus Anton Vanegas, charged with criminal trespass and damage to property, 22 CR 008586G. You've been advised of your right to remain silent, and your attorney is Ms. Woodbury. Any priors, Mr. Toussaint?
Oh,
Mr. Borger, any comment?
Thank you, Honor. The state's asking for a $3,000 surety bond along with the conditions of no further contact with Jaliyah Arrington, Jaaliyah Arrington, Arrington. Stay away from 2216 Jefferson Drive, and enrollment in alcohol and drug evaluation and any treatment deemed necessary. Your Honor, in this case, the defendant was in Miss Arrington's car, and he was upset when Miss Arrington refused to drive him to the liquor store, and that's when he kicked Miss Arrington's windshield, causing around $500 in damage. Again, we're asking for this alcohol drug evaluation because for Mr. Venegas to act this way over a trip to the liquor store is quite concerning. Again, he can get this treatment while out, even on a low surety of this matter. I think Miss Arrington might be on Zoom.
She is. Was there any indication that he was under the influence at the time? I didn't see that in the warrant. So.
No, so the warrant doesn't state whether he was or was not under the influence, but it does seem that alcohol does strike him a certain way if he's having an outburst over his ability to go to a liquor store. And when that ability is denied, his reaction is to kick a windshield. So again, that's why we're coming in with that evaluation. And we would like for there to be no guns, drugs, or alcohol while on bond.
Excuse me.
Yes, Ms. Arrington, I did notice you're there. If you'd like to start your video, I'll be glad to listen to what you have to say. All right. Ms. Arrington, if you'd like to raise your right hand, do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes.
All right. So how's the windshield?
It's fine. I just wanted to acknowledge that I never wanted to press any charges at all. That was never expressed from me. That was pretty much what I wanted to say, and that I don't want a no contact order. I'm currently pregnant right now, and I need help as far as going to the doctor's appointment, and that support.
Who called the police?
I didn't call the police.
Yeah. All right. Ms. Woodbury?
Yes, Judge. So we would be asking for a signature bond, given that Mr. Venegas has no history, given that Ms. Arrington is on the line saying she wants contact and seems to be saying she's not afraid of him and did not want this case to happen. This is an allegation of a property crime. It's not a crime against an individual. Judge, just briefly, Mr. Venegas, his last job was as an Amazon delivery driver. He does have an uncle in Georgia. So, Judge, we would be asking for a signature bond, a no violent contact, and no stay away order, especially because the incident was not alleged to have happened at that Jefferson Drive location.
All right. So, Ms. Woodbury and Mr. Borger, as you heard the victim testify, apparently she and the alleged defendant apparently are going to have a child. So this would be upgraded to a domestic violence situation or family violence situation. Yes, and the caller appears to be the victim's mother at 2216 Jefferson Drive.
So the mother placed a 911 call, the victim's mother.
And Judge, my understanding is that, oh, I'm sorry.
Sorry, my mom does not stay here. She doesn't stay here.
I didn't say she stayed there. I was just wondering who called the police.
I'm so sorry. I thought you said she stayed there.
Mm-hmm. I just said the incident occurred at Jefferson Drive. I have no idea where your mother lives.
The incident occurred in a vehicle.
How you doing, Your Honor? Nice to meet you. I just wanted to say that me and Jaliyah, we've been working on our problems, and we plan on getting married next year.
How did you work on your problems?
Because we used to argue a lot, but I've been working on it. I ain't been arguing. I've been leaving.
This
Mr.
happened-
Venegas, I would advise you to think carefully about what you say. Everything's being recorded and can be used against you in the future. So I would advise you to limit what you say.
Yes, I do not live with Jalea. I stay with my uncle. I just come through and see Jalea due to.
Mr. Venegas, the reason why this is a domestic violence situation is because you and she share a potential child. So you all are intimate partners. And according to the warrant, you occasionally stay at her apartment.
No, ma'am.
This is a domestic violence situation.
No, ma'am. My ID, my address is not the same as hers. Your Honor.
Okay, I'll take that. You don't live with her, but you
Okay.
both are intimate partners, correct? All right, I guess no response is something else. So you're finally listening to your attorney.
Okay, and about the bond situation, how much was the bond?
I didn't say it.
Mr. Venegas, she hasn't ruled yet.
Okay, I'm sorry.
Bond is going to be set at 3,500. It's going to be a signature bond through pretrial services. Mr. Venegas, you're going to report to pretrial once a month. You are to have no further contact with Jalea Arrington. You're to stay away from the 22, I think it's 16, Jefferson Drive in Atlanta, Georgia. No contact means you have to stay 200 yards away from her. You're not to communicate with her in any way, form, or manner. You are to not communicate with her through social media, a phone, a third party, anything to that effect. If this case is still open and pending and you would like to have visitation with the child in question, you would need to file a separate legitimation action to establish visitation with the child in question, which will only be done through a third party, a neutral third party. No illegal drugs, no weapons, and no firearms. And as this is a domestic violence matter based on the sworn statements from the victim and from the statements that you've made, I'm going to require you that while you are out on bond, that you are to complete an alcohol and drug evaluation and submit yourself to any treatment if required. You're also to complete 8 anger management classes at your expense. The anger management classes will take place within 30 days of being released. So when you report to pretrial on your second visit, you must show proof that you are enrolled in an anger management program to complete the 8 classes. Your alcohol and drug evaluation must be presented within 60 days of being released. And if any treatment is warranted, you must submit yourself to that treatment at your expense. Your next court date will be sent to you. I don't know if we have this current address. Let me check. Your next court date will be, well, it's the Jefferson Drive. Well, looky. Apparently he doesn't live there, but his address is listed as such. So do you have a different address, Mr. Venegas?
Thought he's being slick.
Yes, ma'am.
All right. Ms. Woodbury, do you have this different address?
I do not at the moment, Your Honor.
Your Honor, can I say something, please?
You might want to give the Deputy Francois your current address so we can send you notice of your next court date, because failure to appear will result in a bench warrant being issued against you.
My address.
I can't say anything.
Ma'am, me and Jalea, it says on his paperwork that me and Jalea live together, and we don't live together.
Okay, I that's why I'm asking you for your current address.
And I've been locked up for going on 3 days already.
As long as it's not past 72 hours, it's still legal.
I can't say anything.
Not yet. Anything else, Mr. Venegas?
I don't know, I'm just confused right now.
You're charged with a crime and you got a bond and you need to come back to court when summoned.
I know that, but I
Simple.
would really like to support my wife and my child.
Are you married to Miss Arrington?
I will be marrying her now.
Well, then you can't call her your wife until you have a legal marriage.
Okay.
All right. Yes, Miss Arrington.
I just didn't understand why, because I said that I didn't want a no contact order. I'm not afraid. I'm not in danger. and I never stated that.
Understood. But Miss Arrington, here is a very simple lesson. When
Okay.
there is some degree of violence involved and the police get involved and someone gets arrested, and it's a domestic violence situation, the decision to prosecute is not with you.
Okay.
The decision as to the conditions of a bond are not with you.
Okay.
And Judge, I just want to state one more time for the record so it's clear. The allegation was a criminal trespass for breaking a windshield. There was no allegation that he put hands on her.
Understood. Property damage is still an element of violence. I didn't say it was violence against her.
Yes, Your Honor.
It's like breaking a door or throwing a brick through a glass window. I certainly wouldn't like to be on the other side. All right. Okay, thank you, folks. He's got a signature bond. All he has to do is comply with it. And hopefully, if things work out, we can amend the order.
It's kind of harsh, but they want the people to cool off. They want it to, they don't want more problems. That's the biggest thing. And that's why I think she gave him a $3,500 signature bond. That's a big reason for him to be good and do what he's supposed to do. Because if not, he'll have to come up with $3,500 to get out. So I can understand the reason she's doing it, but keeping in mind there was he just kicked the windshield out. That was all. So we'll see if that holds true down the road.
Position 23, Walton.
Justin Matthew Walton is accused of battery, domestic violence in case number 22 CR 008584E. This is from December 30th, 2022. Mr. Walton, you've been advised of your right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Woodbury. Any priors, Mr. Toussaint?
This is fourth arrest. He don't have any violence. 2013 driving without a valid license. And he had another one from Georgia and an 05 arrest out of Florida.
Okay, got it. Thank you. Mr. Borger?
Thank you, Your Honor. The state is asking for a $5,000 surety bond, along with the conditions of no further contact with Crystal Stewart, Krystal Stewart. Stay away from 414 Haldane Road, enrollment in the anger awareness class, and no guns, drugs, and alcohol while on bond. Your Honor, in this case, the defendant punched Ms. Stewart in the face, caused bleeding to her mouth. Sounds like this might be upgraded to a felony due to the extent of the injuries. You looking at Mr. Walton's cycles here, I understand that he doesn't have any violence, but he does have an inability to comply with just basic rules of the state, and like driving on a suspended license. Those are not things that are encouraging in his ability to comply with court orders, get his documents in a row, and make sure that he appears when asked to appear, because he's been asked not to drive and he's continued to drive. I think Ms. Stewart is here on Zoom, so we can hear from her as well. But that is why we're asking for a $5,000 surety bond. Nothing further.
Crystal Stewart, if you're present, I'm trying to see.
I'm here.
All right.
I'm here. Hello.
Hello? Yeah, all right.
I'm here. Let me get the video. I'm sorry. Can you see me?
No.
I'm sorry. I'm not too good with the Zoom. Can you see me now?
Yes.
Okay. Hi.
Hi. Could you place you under oath, please? Do you solemnly raise your right hand?
Sorry.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, Ms. Stewart, I've read the warrant, and this incident just happened yesterday. Did you have anything to add, or
Correct.
don't have to say anything otherwise?
He's not a violent person. I have his house and he was letting me stay there. We do share a daughter, so and he does help with her. So I would appreciate if he's still able to do so. I'm not afraid of him, and he, like I said, he's not a violent person.
You did hear the prosecutors say they were thinking of upgrading it to a felony charge based on the nature of the injuries.
I did. Actually, when the police first arrived, I told them that I didn't need any help and that I was fine. There was no EMS involved, and I am fine. I don't see why that would be necessary.
Okay. All right, Miss Woodbury.
He punched her in the face, and he's not a violent person. I don't get it. I've never punched a woman, much less in the face. How can someone do that? And I feel for the lady. She loves the man, obviously, but I really feel for her. She's in a bad way.
Just a question for Ms. Stewart of clarification. Ms. Stewart, do you want to have contact with him?
For the sake of our daughter, yes.
Okay. So Judge, Mr. Walton, he was working as a paramedic for Atlanta Fire. Judge, I did not hear any failures to appear in that history, so we do know that he comes to court. I would ask for no further violent contact. He does tell me that his name is on the lease at that 414 Haldane Drive address. If the court is inclined to issue a stay away, we would ask for one trip with an officer.
Bond is set at $3,500. It is a signature bond through pretrial services. No further contact with Crystal Stewart. He is to stay 200 yards away from her and not communicate with her in any way, form, or manner. To stay away from 414 Haldane Drive in Atlanta, Georgia. He's allowed one-time visit with a police officer to retrieve his personal belongings. If Miss Stewart has vacated the premises, then he would be permitted to return to the location. That would be obviously before the one-time visit. Unless, I'm so sorry, Miss Stewart, are you married to Mr. Walton?
No.
No. Okay.
No.
All right. So present time, if he wishes to have any kind of visitation or custody with his daughter, he would need to file a separate legitimation action and obtain a court order to establish that visitation schedule. But presently, he's to have no contact with either one of them. Yes, Mr. Walton.
I just want to say, one of the charges that Mr. Borger said was, I got issued a license, and
I'm not holding that against you. You've got a signature bond through pretrial, but because this is domestic violence, I always try to follow a protocol of what we call a breathing room or a cooling off period. So there shall be no contact.
my name is on the mortgage at the house. I don't, on that house at 414. So
Well, then you better make sure you maintain it in order to keep your credit history good.
She doesn't rattle at all.
thank you.
Thank you.
All right, Judge, we're completed here in courtroom 2. Happy New Year to you.
Happy New Year. Thank you.
Thank you.
Courtroom 3. Oh, I guess we're going to the South Annex at the Atlanta Center. And we have a young lady there. Who do we have, please?
Position number 5.
Okay, thank you. This is Charmaine Clopton, accused of battery from June 7th, 2021. Ms. This is an announcement to all the 4 individuals at the South Annex. This is a first appearance calendar in which your cases have already been formally accused. Hence, your cases are with the State Court of Fulton County. Please remember that you have a right to remain silent about the facts of the case. Anything you say about the circumstances of your case, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, a public defense attorney will represent you. And if it's determined that you do not qualify for their services, after today, you would need to hire your own private attorney. Okay, Ms. Clopton has accused of battery. This is not a family violence matter stemming from an incident at I guess some kind of daycare, the Precious Jewel Learning Academy. Mr. Tucson, any priors?
4 total. 2015 theft of property out of Tennessee. 2019 forgery in the 3rd degree dismissed. 2017 shoplifting.
All right, thank you. Mr. Berger, well, I don't know if the child is still attending that particular school. What's your recommendation?
Yes, Judge, be back to Mr. Carr.
Oh, Mr.
But,
Carr, sorry.
Yes, Judge. In this case, the state's recommending a $1,500 surety bond, as well as no further contact with that victim, Miss Teresa Carter. And we would advise a stay away from that incident location, the Precious Jewels Learning Academy, just because, as I'm sure that you've read in the warrants, that Miss Carter came up to her saying that she owed the late fees on the child care, and her response was to get angry and punch her in the face. So we do believe, with a stay away from this location, especially. We're not sure. We had called and texted Miss Carter this morning. I'm not sure if that's where she still works, but we would have concerns about her returning to that incident location.
Okay, thank you. Ms. Bronstein, anything else to add?
Yes, Your Honor. Ms. Clopton is 30 years old. She does have 4 children, 11, 9, 6, and 1 month. She just had her 1-month-old child. She had a C-section and is still healing from that. She was working at Church District, and obviously when she is healing from having a child in a C-section, she is not making any money. I do want to point out that this case is from over a year and a half ago. And there appear to have been no issues since. According to pretrial, there is no violent history. Like I said, based on the fact that she is a new mother and is not working, she does not have any money coming in. She is a high school graduate with some college at Atlanta Area Tech. She was focusing on business and finance. We are asking the court to consider a signature bond in this case.
Bond is set at $3,000. It's a signature bond through pretrial services. No further contact with Teresa Carter. To stay away from 1284 Joseph E. Boone, the Precious Jewel Learning Academy. No illegal drugs, no alcohol, no weapons, and no firearms. Her next court date will be sent to her current address. And do we have it?
Yes, the address, let me just double check. The address she gave me, I believe, is the one in Odyssey, and if that did
I have 1247 Joseph E. Boone.
Yes, apartment 35.
All right. So she cannot return to the school that appears to be nearby.
Okay.
All right. Thank you.
Thank you.
That's unreal. I guess there's some late fees that she didn't pay, and they're trying to get them from her, and she punches them in the face at a daycare. Kids everywhere. Man, I hope her kids don't take after her with that kind of violence.
Next, we have position number 6, Ms. Davis.
Catherine Davis is accused of reckless conduct from September 8th, 2022. Ms. Davis, your case number is 22 CR 008 574F. And you've been advised of your right to remain silent, and your attorney is going to be Ms. Bronstein. By any miracle, is Mr. Nakonoko present? No?
Yes, I'm present.
Okay.
All right. All right, Mr. Tucson, any priors?
Sorry?
And not you.
11.
Before we get too far in this one, let's remember what we had. We had a gentleman that kicked out the windshield or busted the windshield of his fiance, I guess, car, and then we had a man who hit his wife square in the face, and both of them were no contact. Period. Right?
Please be silent.
11 total.
Okay.
Last was 2013 probation. She got a bunch of probation violations and some forgery in her history. She don't have any violence in them.
Okay.
Well, from 06, simple assault conviction. That's it.
You. Mr. Carr?
Yes, Judge. In this case, for the reckless conduct, we would be recommending a $7,000 surety bond, as well as a no contact with Mr. Nestor. Sorry for
I'll
mispronouncing
just go with
name.
Mr. Nestor. Yeah.
Yes, that'd be great, as well as no drugs, alcohol, or weapons while out on bond. The allegations, I'm sure that you've read through this, are very concerning. The fact that the victim was that the defendant got angry and that she ended up hitting him with her car. At the end of the day, I know there are allegations. It's definitely going to be more investigation on the state side, figuring out exactly what happened here. But at the end of the day, the victim was not charged with anything. I know that she has claimed that he was the one that initiated this physical contact. That's not what the police ended up finding. They found that she was the primary aggressor and that she is very lucky that this case just came down to a reckless conduct and that more injuries weren't done to the victim.
To me, at the very least, assault with a deadly weapon, I would think. If not attempted murder. Maybe hard to prove, but she certainly assaulted him with a deadly weapon.
It's very serious what had happened in this case. And on top of that, she does have the previous FTAs and the probation violations. Our biggest concern is just that any kind of incident rising to this level would happen again. That's why we've suggested the surety bond in this case. And I know we had our victim advocate had spoken to Mr. Nestor. I know that he says the situation's behind them and that he would like to resolve things. However, just given the gravity of what had happened in this case, we do believe that a no contact's appropriate.
All right. Mr. Nestor, did you want to contribute or shall I move on?
Yeah. I want to talk something.
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
So the allegation is that apparently there was a dispute and that you were dragged by the car.
Yes, ma'am. But yeah, since that happened, I already spoke with my wife about this issue, which been since that happened after 3-4 days, 1 week. After 1 week, we start living together again. Since that happened, she's good. I mean, she don't act like that anymore. I mean, she take care of the house. Everything is good now between us.
Okay. Thank you. Ms.
Yeah.
Bronstein?
Thank you, Your Honor. We'll be representing Ms. Davis while she's in custody. I did tell her she's just slightly over, so I told her that if anything changed to bring her pay stubs to my office and we can do a new application. She is 40 years old. She's born in New York, but moved to Atlanta as a small child and has been here ever since. Her family, her siblings are all here. This case is from a few months ago. We are asking for a signature bond. As I said, she doesn't qualify, but barely. The qualifications for misdemeanors in Georgia is very, very low. She told me that she was head of household and with her child and husband. She really doesn't have much money. So she's asking for a signature bond. We are asking for no violent contact and that there not be a stay away from the home that they share.
Bond is set at $5,000. This is a signature bond through pretrial services. No violent contact with Nestor Nokonako. Did I say that right?
Yes, ma'am.
Okay. Nokonako. Yes. No violent contact means there cannot be any further physical or verbal altercations between the two of you. If there are and the police get involved, well, Miss Davis will lose her bond and be back in jail. She will have to report to pretrial once a month. No illegal drugs, no alcohol, and no weapons and no firearms. She can return to the marital home. I'm assuming that's on Turkill Avenue.
Yes, Tokyo Avenue.
All right. And while she's out on a signature bond, she will enroll and complete 12 weeks of anger management classes, which must begin within 60 days of being released. That means by the third visit with pretrial, Ms. Davis must show proof that she's enrolled and beginning her anger management program. The classes and her next court date will be set to the Turkle Avenue location. Ms. Davis, after today, you will need to hire your own private attorney to represent you. So when you come back to court, make sure you bring your attorney. Thank you.
Kind of different, huh? What am I missing? What's different between the first couple of DV cases and this one? To me, this one's the most serious. He hit with a car and drug. I don't know. If y'all can, you've seen what I've seen. If you can figure it out, please let me know. But it doesn't seem to be the same at all. I don't know. Well, that's what I got time for today. Mike's going to be coming on here in a little bit, and I'll be over here watching. If y'all want to come over there, that would be great. I hope y'all had a wonderful New Year's Eve and a good night last night, and everybody's nice and safe and at home with their families. I hope y'all have a wonderful New Year. Look forward to seeing y'all again.